Yes, my father has worked. It is you who have agreed it. Yes, your brother has worked. I say whether you should also practice that particular correspondence. It is handwritten. I never said I have written it. It is yours. But one communication yes, and in fact, mother has a hand that edits this document, saying that this is the document, and someone has written it in the year 1985. I have not taken position, neither they have taken a neutral position. I have not said that the 1985 document has been written by my COMs. I have also not said that he was working in 1981. I have only said that the documents which are available to me is only of 1965. After 1965, none of it was. But he died in her. But I never said that, madam. That is only one correspondence. What yes is handwritten. And that copy has been forwarded to the minister also. And it is the minister who has produced this document in the next week. Paragraph 28 I read, madam. Then after paragraph 30. Range forest officer versus Adimani in our opinion, tribunal was worked in the following terms. But I don't know these are the facts of that particular case. It is difficult to accept the logic behind next stage. It is difficult to accept the logic behind the said findings only because the appellant failed to prove its plea of abandonment of service by the respondents. The same in law cannot be taken to a circumstance that the respondent have proved that case. The circumstantial evidence is vital, my lord, so far that particular correspondence is concerned. Yes. The circumstances relied upon, in our opinion, the wholly irrelevant for the purpose of procedural whether the respondent is permitted to particular service or not. A party to the list may or may not succeed in its defense. A party to the list may be filing representations or raising demands, but filing of such representations or raising demands cannot be treated as circumstance to prove the case. The last judgment which I am placing reliance upon is AIR 1966, Supreme Court 605. The equivalent is 1965 SCC online, Supreme Court 552, paragraph 15. Paragraph 15, 1 5. Appearing at page 14 bottom, my lord. The pages are there at the top. Page 14 bottom. So here we are talking about, my lord, 116B, the passage of time. The inference of continuity. Inference of continuity. And a presumption as to continuance of a state or thing. That presumption which has been drawn. Presumption as to continuance of a state 1965 to 1981. So the Honorable Supreme Court, my lord, if you lordship kindly see page 14, paragraph 15 from the bottom. The survey records of 1892, 1895, 1904 and 1909 disclose that the ancestors of the plaintiffs held some of the frontier plots of Rubamar. The High Court was therefore asked to draw the inference that the ancestors held those plots during 1845 to 1863 when the Tawfir land aggregate. The question is whether such an inference should be drawn. Now, if a thing or a state of things is shown to exist, an inference of its continuity within a reasonably proximate time, both forwards and backwards may sometimes be drawn. The presumption of future continuance noticed in illustration D to section 114 of the Evidence Indian Evidence Act 1872 in appropriate cases, an inference of the continuity of with respect retrospectively has been recognized both in India and overseas as well as in England. The broad observation in Mohammadarab, Hungary, and so that there is no rule of evidence by which one can presume that continuity of things backwards cannot be supported. Thereafter, kindly mark. The presumption of continuity weakens with the passage of time. How far the presumption may be drawn, both backwards and forwards, depends upon the nature of the thing and the surrounding circumstances. In the present case, the High Court rightly refused to draw the inference from the state of things during 1892 to 1899 that the ancestor of the plaintiffs had funded in 1863. The High Court pointed out that even during 1894 to 1895, the ownership of some of the plots had changed, also that the frontier malls and corresponding tawfiq were not always held by the same person. In 1845, part of the mall lands were under water. The frontier mall lands were reformed from so to so. It is well known that settlement of chor lands are seasonal and temporary. There is a considerable gap of time between 1892 and 1845. It is not safe to assume that the state of things during 1894 to 1995 existed during 1845 to 1863. In our there is a gap of around 17 years. Thank you. Though my learned senior friend, my lord, my learned friend, my lord, shown, my lord, innumerable documents, and just adding two things, my lord. Lordship, kindly at the outset, my humble submission, there is not only one communication. Number of communications are there up to 2015 by the, my lord, the appropriate authority. The order passed by the tribunal has not been challenged by them. There is a direction for reconstruction of record. One by one. You are saying there are other innumerable communication. Let kindly come to page 23. Page 23 we have seen. Only one word. Second paragraph. When he was on, he has paid salary up to 1965 when he was on deputation at Elim Hospital. So he was working in the Katwa Hospital. Salary has been paid up to 1865. Then, my lord, on deputation, which is consent, subject to my lord, the approval, my lord, consent is required to be taken in case of deputation at Asansol LM Hospital. And Asansol LM Hospital is not in a position to supply any document. Though Katwa is in a position, my lord, to supply certain document. Here, lordship, kindly see up to 1965. Yes. Here, lordship, kindly see. My lord, repeatedly they are saying, my lord, who has signed this, whether it is the appropriate authority or not, is raising all questions. My lord, official secrecy act was there, no document should come in my hand. But they have sent it. You explain to us page 26. Lordship. Who has given the answer? Lordship. My lord, page 26. Yes. Page 26, my lord. From CMOH by the PA to DHS. True. But previous, my lord, page 24 may kindly be looked into. Yes. Letter addressed to Director of Health Service by the CMOH. Here, my lord, at the top, prayer of Bhaktirani Ghatak, so-and-so ex-ambulance driver of SD Hospital for employment of a son on compassionate ground. The following particulars of the above subject are forwarded herewith for your favor and taking necessary action in respect of employment of the son of the deceased ambulance driver, let Sochipati Ghatak on compassionate ground. This was the letter, my lord, initiated from the district headquarters. I'm coming. So, my lord, the hierarchy, DHS and my lord, the district, my lord, the health officer is not on the same. As a result of which, secretary of DHS has been written, instructed, kindly see, my lord, I am directed at the top, lordship will find, page 26. I am directed to request you. So, as it seems, my lord, he was duly. Stop, sir. We do not want to read the end. Lord. We are putting a question. Lord. This is a letter issued by PA to the DHS. Lord. He is writing to the CMOH. Lord. Referring to page 24. Lord. That is 22nd June 18. Lord. That please furnish me answers to these questions Lord. Which I have framed. Lord. So how in the letter of the PA to DHS the answer will be incorporated?
This answer must have been given by CMOH.
Well, they have referred this particular document to us. At the bottom, Lord, you will find Srimati Bhakti Rani Ghatak. I have got it. It was in my custody. I have enclosed the annex with my all documents. Litigation in different fora.
With request, it was forwarded to you with a request,
Lordship,
to submit the particulars as asked by the PA
to DHS.
So you furnish the particulars.
Yes, my lord. Yes, my lord. Kindly see. Thereafter, my lord.
So this yes may have been written by you also.
My lord, I cannot, my lord. My lord, my two daughter and son, my daughter are in the tender age. They are minor at that point of time. My lord, what happened? These are the
So you mean
this is that copy, my lord. Even, my lord, at the bottom, lordship, kindly see, another candidate is willing to be employed in the post of foolish. If so, he is, my lord, the chest, height, weight may please be furnished. My lord, if he is a temporary employee or terminated employee, my lord, whether there is any scope, my lord, to inquire and to take all initiative to, my lord, appoint in the, my lord, in the civil post. My lord, that is the question, my lord. Then, lordship, kindly see, 3 months inquiry committee was constituted. Information is also, my lord, shared with us. That is page 27. At the bottom, lordship will see, Chief Medical Officer, my lord, constituted this particular committee for the purpose of compassionate appointment. Then, my lord, kindly see 2008, page 29. My lord, the repeated.
yes,
Page 29, annexure P5. Here, my lord, in continuation to the office order dated so and so, inquiry into the matter of prayer of employment of compassionate ground in respect of, my lord, Kalachand Ghatak, son of Sochipati Ghatak, one said that they have themselves stated ex-driver Katwa hospital, and in respect of Kumari Anamika Mullik, daughter of late so and so, ex-driver of the Deputy CMH3, my lord, wing of COMH, Bardhaman will be held on Hato, my lord, in the office of COMH, Bardhaman, my lord, on 29/4/2008. Here also, my lord, at the bottom, now, my lord, for the first time, my name is appearing, Kalachand. Because 2006, my mother died, Bhakti Rani died. My name is there at the bottom, Lord, you will find. Then Lord, kindly see. Page 31, all details, my lord. My lord, the district headquarters, chief medical health officer of the Bardhaman district, my lord, dispatched this particular document after collecting it from me. Then, my lord, my lord, they failed to, my lord, pursue this matter. Only in the year 2015, page 32, my lord, they wrote a letter, Aruna Banerjee wrote a letter, who is a daughter of Suchipati Ghatak, addressed to the, my lord, government of West Bengal Commission for Women. They took some initiative, my lord, to inquire into the whole matter. Kindly see page 33. At the top, reminder that possibly the other letter is missing with us. Then, my lord, kindly see, inviting a reference to the above, you are hereby requested to furnish the latest development regarding disbursement of the pensionary benefit in respect of late Shochipati Ghatak. Within 15 days, my lord, there was no iota of doubt of my entitlement to get, my lord, the pensionary benefit at that point of time in the year 2015, my lord, by, my lord, Special Officer Pension, Directorate of Health Service, West Bengal. Then, my lord, kindly turn to next page, 34. Here, my lord, as to why my claim for compassionate appointment has been rejected, my lord, they have taken this plea. The application was filed after a considerable period of time. No, my lord, that is within time.
Human committee report was not.
We don't know, my lord. That was not forwarded to us. These are the
Was within time, you said.
my application for compassionate appointment, page 23.
81 was your.
Yes, date of death. And my lord, within the 2 years stipulated period, I have applied.
But you approached the tribunal
Yes,
after.
my lord, that was some mistake, my lord. Helpless person, my lord. They are that being the situation.
Your application for compassionate is which date?
My lord, kindly lordship will find from page 23. 23 and then my lord 24. 24, my lord. Prayer for Srimati Bhakti Rani Ghatak for employment of her son on compassionate grounds.
This was on 84.
Yes,
How you are saying that it was
no, my lord, that's my mistake. But by the Suchipati died in the year 1981, the December. My lord, there are certain gaps.
Yes, then what?
Here, my lord, the rejection ground was there.
What other document you are?
I'm sure. On the first round of litigation, my lord, the State Administrative Tribunal is rejected. Then, my lord, this honorable court relegated this matter with a certain observation.
You have the original application copy.
My lord,
Layered portion of the original application. You have it.
that is not enclosed over here.
Yes. Next.
Page 50 may kindly be looked into as to why this was, my lord, the findings of the, my lord, on writ court.
That is after demand.
Yes, no, before that.
Page 50 is after demand.
No, my lord. Oh, yes, before that, my lord. Before. I'm coming. Kindly come. My lord, here, my lord, page 42, second paragraph.
Yes.
Fourth line, there being no prayer for setting aside of the order denying compassionate appointment and for a consequential direction upon the respondent to consider the case of either of the petitioner for such appointment, the tribunal was in error in not examining the prayer made in the original application for release of date from the tribunal. The thing is this, my lord, submitted that the record as a result of which the first round of litigation tribunal rejected my claim. My lord, that was not.
No. He didn't say. He said that it was dismissed since you have approached belated.
Deeply obliged, my lord. I'm correcting myself. Then, my lord, lordship, kindly come to page 46. That is the, my lord, the second round of litigation before State Administrative Tribunal. I'm drawing lordship attention, page 50. But after skipping 3-4 lines, second paragraph, the application, the death certificate is with the respondent authority, appropriate order may be passed. Referring to the reply filed by the state respondent, particularly paragraph 15 thereof, is submitted that since the service book of the disease is not available, no new service book has been directed to be constructed due to lack of instruction. And the only stumbling block, lack of instruction from higher authority. And as it is evident that if directed service book can be reconstructed, appropriate order may be passed so that the relief short term may be granted.
This is your submission.
No, kindly see, I am showing my lord, page 236. They are affidavit before the tribunal. paragraph 15. Well, referring paragraph 15, we have made this submission. Subject to correction, Lordship will decide, my lord, whether that was our proper submission or not. Page 236, I am drawing Lordship attention, paragraph 15, page 240. That you got it, Mary?
Yes.
With reference to the submission made in the paragraph 1, so I submit the no further arrangement for compassionate appointment could be made due to the lack of proper instruction. My lord, since 3 months committee and thereafter nothing done, possibly my lord trying to explain by the state advocate in the state administrative tribunal. I submit that the service book of the disease is not available and no new service book has been reconstructed due to the unavailability of instruction from higher authority. And adequate information for reconstruction of service book is available. So, my lord, this is their affidavit. On the basis of that, we have made the submission, and court was kind enough, honorable tribunal was kind enough to direct the appropriate authority, my lord. That is, I am reading, my lord. Once again, my lord, same thing. It appears, page 51, I am reading. It appears from the annexure that the Sochipati Ghatok worked in Katwa SD Hospital, Badwan, so and so, and was paid salary up to 18 May 1965. So, my lord, so far the liability of payment is concerned by the Katwa up to 18th May 1965. Whether the payment has been made by the LM hospital, it is up to the LM hospital to supply all those documents. When he was on deputation on LM hospital, my lord, once again, my lord, subject to correction, deputation.
Is it believable, Mr. Chaudhary, that my husband last got salary in 1965?
The act is there, my lord, there was.
So from 65 to 1981 is a period of 16 years.
Yes,
You will not produce a single document that is the payslip. Any one document.
only difficulty, once again I repeat and reiterate, the document which they have sent after the death of my father or death of my lord, the husband of Bhakti Kuti, my lord, we had trying to, my lord, enclose all those documents. Possibly these documents are not lying with us.
Your wife expired in 2006.
My lord, is a illiterate lady of village.
No explanation for it.
My lord, illiterate lady of a village and son and daughter at tender age. That was the explanation given by the
Fact that you also do not have any document to establish that there was any service rendered by your father.
because of for that reason that the question of burden of proving presumption are arising.
Yes,
Lordship will decide.
to us.
Well, at page 51,
We have seen page 51.
therefore, thereafter no records are available. He expired on so and so. There is a death record, death of record as it appears from the reply that service book could not be constructed due to non-availability of the instruction. And my lord, his application is disposed of, directing the chief medical officer Bardhaman, the respondent number 3, to first decide of coming of finding order regarding the identity of the application. Possibly, my lord, there is no, my lord, iota of doubt so far my identity is concerned. They went to my house on innumerable occasions. Police went there, and my lord, they have taken signature from me and length of service of the disease government. My lord, turn to next page kindly, my lord. Employee of Sochipati Ghatok, after verifying the record within 8 weeks from the date of presentation of a copy of this order, if he is satisfied about the identity of the application and confirm the length of service of the disease government employee, he shall immediately seek the necessary order of reconstruction of the service book. And nothing done, no appeal preferred by them. They are not asking for, my lord, the modification of this particular order passed by the honorable court, which is not supervening impossibility cannot be implemented in any manner whatsoever. Then, my lord, when the state administrative tribunal was not available, we approached by the Lokayu. And Lokayu passed certain order, and thereafter we approached the Supreme Court. Now, my lord, lordship, kindly see. My lord, there must be in each and every government house, my lord, there is, my lord, rules to maintain record, to destroy record. Here I don't know, my lord, this is not beyond my knowledge, my lord, I kindly excuse me. But destruction of this record by the Katwa hospital is still maintaining the record. They are of the opinion 65 is okay. After 65, we are in dark. So far LM hospital is concerned, they are not in a position. So far the Directorate of Health Services is concerned, so it is to be presumed once again, my lord, record is required to be maintained. Service book is required to be maintained, my lord, in a the indefinite period. Here, my lord, how the record was destroyed, my lord, they did not explain it. And on the number of occasions,
They don't say destruction, they say not available.
no, not available. They are not denying that I am not their employee. They themselves term me as ex.
Yes, certainly. They are saying that you 19,
Lord,
1965 you received the salary, deputation, no record.
Lord.
No record. So this writing died in harness is a discrepant observation.
So they themselves, COMH of Bardhaman, DHS of the state of West Bengal, every authority at that point of time took all initiative. They formed my lord 3-man committee, and my lord requested me, or my lord, they intend to know whether I intend to join in the service of police also. Well, that being the situation,
Where do we find?
Lordship kindly come to my lord. This
Page
25. My lord, the page 26 is my lord the typed copy. 9. Whether the candidate is willing to be employed in the post of police constable, because compassionate appointment, father was my lord the driver, son was not. Possibly, if so, the measurement of chest, height, weight may please be furnished. Written consent to this effect may please be furnished. Agreed measurement are given below. These are the agreed measurement.
You were a minor at that time.
True, my lord. Sometime, my lord, when the application has been made, they are not raising that question. They can insist the Bhakti to do the work of proof deed. That was not their intention. They are in favor of the family at that point of time. My lord, this is my lord humble submission, my lord. Now, my lord, I intend to rely upon the judgment. This is 2004 9 SCC. 2004 9 SCC. Para 6. 6. Page 60. 2004 9 SCC, page 68.
Para 4.
Para 6, my lord. Para 6. The only point for consideration is whether the respondent was in service or not at the relevant point of time. The tribunal, only on the basis that she was not able to produce the appointment letter, ruled that she was never in service. On the other hand, the High Court, relying on the document like transfer order and joining report, found that she was validly in service. There is also a positive evidence to that effect that she was paid arrear during the relevant period of time. On this goes to show the president of the district board appointed her as a teacher and she was working as one. This is one, my lord. Then, my lord, turn to the next page. Last 3-4 line. It's 71. My lord, after skipping 1, 2, 3, 4, 5, 7, 8 line. Once no order of termination or dismissal is produced. So far, they did not produce any document. Even my lord, they did not indicate there was a disciplinary proceeding for unauthorized leave. So, my lord, nothing produced on the part of the state authority, my lord, that being the situation. Now, my lord, I am relying upon Tarsing Singh judgment, continuing cause of action, my lord. My lord, no third party right has been created. It is a question of my terminal benefit. My lord, I can, my lord. Paragraph 5 and 7, I am not reading, my lord. This is
You
widely.
have not said that your claim is delayed.
My lord, kindly,
Your compassionate claim was delayed.
and the other question is,
No, Mr. Siddiqui said
so my lord, I am not relying upon this Tarsing Singh.
that was when
Lord. Then, my lord, kindly come to my lord. in the year
paragraph 23.
But I think, my lord, subject to correction, presumption
Is para 23.
my lord. The question of presumption, my lord, it is to be presumed, my lord. I was in service and continued up to 1981. Is squarely applicable so far my case is concerned.
Which one you are?
Well, it's para 23. It is settled law. The presumption of fact is a rule in law of evidence that a fact otherwise doubtful may be inferred from certain other.
Where you are reading?
Para 23, lordship.
Yes. This quote in Vidya Devi. 23.
No, my lord. 2012 10 SCC lordship got it. My lord, the pagination which I have made, so far my copy is concerned, my lord, my class did not do it.
T. Shankar Prasad.
Tulshiram Sadhu, Shurjo Bongshi. My lord, after Tarsen Singh, my lord,
Tulsiram Sadhu. Yes.
para 23. It is settled law that presumption of fact is a rule.
Yes.
My lord, most humbly and respectfully, my lord, I am reading, my lord. It is settled law that presumption of fact is a rule of law, rule in law of evidence that a fact otherwise doubtful may be inferred from certain other proof fact. When inferring the existence of a fact from other set of proof facts, the court exercises a process of reasoning and reaches a logical conclusion at the most probable position. The above position is strengthened in view of section 114 of the Indian Evidence Act 1872. It empowers the court to presume the existence of any fact which it thinks likely to have happened. In the process of the court shall have regard to the common course of natural events. Turn to next page, human conduct, etc. in addition to the facts of the case. In these circumstances, the principle embodied in section 106 of the Evidence Act can also be utilized. So, my lord, my humble submission, even in the year 2015, they wrote us a letter and referring, my lord, to file of
2015.
yes,
Which letter?
my lord, later lordship will kind enough, my lord, to see page 34. Page 34. They have referred to, my lord, file one relating to relates back 2009, the other 2011. In response to the above mentioned memo, the underside would like to inform you that instant case has been in a file bearing number so and so of this office, from which it reveals that the prayer of the applicant has been rejected by the memo number so and so on the ground of latest submission of prayer as the
I was relating to compassionate appointment.
True, my lord. Since the question of my employment cannot be doubted because a terminated employee cannot ask for, my lord, his relative cannot ask for, my lord, compassionate appointment. Cannot ask for. It's not a question of temporary employee. Then lordship kindly come, my lord. There is some, my lord. Then after skipping, my lord, 6-7 page, my lord, lordship kindly come to, my lord, 1994 supply 2 SCC 56. Bijoy Narayan Singh versus Superintendent of Police.
94 supply
SCC 2 SCC page 56. And does it mainly see the bold portion? Duty of government to justify its action either by proper pleading or producing record. termination declared invalid on account of failure to do so by the state government. So, my lord, they are to, my lord, no pleading has been, my lord, in the fourth corner of the, my lord, fact, it has been received tribunal, the division bench, and the earlier round, and in the report also. They have filed the report, only one plea, record is not available. Paragraph 4, 5, my lord, I am indicating. Now, lordship, kindly see next judgment 2004 3 SCC 753.
Anything else?
This is my lord, only one. Paragraph 9, 10, and 24. And then one, only one. Where the proposition that the presumption. Presumption. Over and above, my lord, lordship, kindly indicated 114T very specifically withholding based document. They are the custodian of all document, my lord. They are the custodian of all document. And I may be excused. Three, my lord, is the Lord Superfine. And last judgment I have referred, my lord, that is Shuk Daptor of Ratra, my lord, the delay. State cannot evade its legal responsibility toward those taking the, my lord, guard of delay and all this. My lord, possibly that question has not been raised by my learned friend. So, my lord, considering all these aspects, and the judgment my learned friend has referred relating to, my lord, employee who is alive. Here, my lord, judgment my learned friend referred, my lord, is the industrial dispute related problem, and my lord, 240 days and other question, where, my lord, the employee is also a person who knows everything, is alive. He is contesting, he is making a claim that I am entitled, and the court was kind enough to observe, no, you cannot. It is your duty. Here, my lord, this gentleman died at the age of 50, and at that point of time, his son and daughter, my lord, was tender age, and my lord, wife also, my lord, illiterate lady, died in the year 2006. My lord, considering all these aspects, my lord, the OA application is available. Page 130. Wait, 0. এটা কি কনফিগারেশনে চললো তো কোথায় করে লিখে
সেটা সাইড অর্ডারটা করবো অর্ডারটা সেটা সাইড according to